Good afternoon. I am Dr. Joaquin Carbonara, Director of the Interdisciplinary Unit in Data Science and Analytics and Chair of the Data Science and Analytics MS. So today, it is my pleasure to introduce the speaker for the last presentation of the DSA speaker series. So Jessica Copeland is a member of the Bond Schoeneck King law firm, and she is co-chair of the Cybersecurity and Data Privacy Group there. She's an expert in cybersecurity. She's a fun and personable and charming individual and a good friend of our program. And I've had the pleasure of talking to Jessica on many occasions, and she's part of several groups that we have. Please welcome Jessica.
Thank you, and thank you for the message of welcome. So today, I appreciate everyone attending, and I promise you a presentation unrelated to COVID, which might be a blessing for many of us. I think we're probably all inundated with information, and this can be a bit of a vacation from that for an hour. So when we talk about the New York SHIELD Act, we are not talking about Marvel's SHIELD, but we're talking about a law that went into effect in New York State. The first phase was in October, and then the second wave of the law was effective March 21st. Okay, so before Governor Cuomo became the biggest hit on TV on a daily basis, he signed into law in July of last year, which seems like an eternity now, the SHIELD Act. Its intent is stop hacks and improve electronic data. Now, that is a very, very high standard and goal, and it was a fallout of the Equifax breach, which affected so many individuals and was an impact of over $8.5 million to New York residents alone. So what the government has done is they looked at ways to impress upon organizations that are responsible for handling electronic data of New York residents and making them basically accountable for how they're handling that data. So there's a bilateral focus. The one path of the law relates to what's called breach notification, and that is associated with if you have had a breach and you know of residents that were affected by the breach, you are obligated to provide notification to those residents. The phase of law that changed in October of 2019 is that now private information, or the definition of private information, the type of data that would trigger a notification, was expanded. And the coverage of business entities was also expanded. So what's important to know is that this piece of the SHIELD Act is not necessarily new to New York. It's just an expansion of what already existed. But then the second wave of the SHIELD Act, which is the cybersecurity mandate, is new. It's the first time that New York has imposed any type of regime for cybersecurity on organizations in New York. And that piece was effective March 21st, 2020. So the first step in understanding how to comply with a law is to understand what is actually covered by that law. And what you learn in looking at any area of law is that there are certain defined terms. So the law that we're talking about tonight defines personal information as any information concerning an individual, including their name, a number. This is actually straight from the statute, so it just says number. It could be telephone number. Social security number is clearly private information, and that's a part of a different definition in the next slide. A personal mark or other identifier. Believe it or not, there's really no known definition for personal mark. What I imagine this would be is if you have some images stored of a person that has maybe a unique tattoo that would help identify that person with one other data element, that could be considered private information and would need to be protected under this law. So we'll go to the next slide where the term private information is defined. And this is the more pivotal definition when we're talking about the SHIELD Act, because this is where you understand what type of electronic data are you obligated to protect, or if you have this electronic data and you're protecting it under the standards set forth that are effective in March, if your company suffers a breach, is the data that was accessed in one of these categories, therefore triggering an obligation to notify affected individuals? So, private information is personal information, which we talked about on the prior slide, a name, a number, a personal mark, or other identifier, plus one of these data elements. So if you have a name and a social security number, if you have a personal mark on a photo that happens to include a social security number that's not redacted, that's personal data. And it is very important to remember that the SHIELD Act is only related to what is electronically stored. So unlike some other privacy laws throughout the country and other regulatory bodies that cover personal data, this is only related to electronically stored data, not paper copies or folders that are in your drawers. So other than social security numbers, which is fairly a given, most people would understand that you can access a lot of individuals' financial information by having their social security number, so that's not surprising. But other pieces of information or data elements that do fall under this category that you might not think of are an individual's driver's license or credit card account number and login credentials, and also biometric information. Biometric data is becoming more and more protected state by state. So certain states actually have their own statute addressing how to handle biometric data. And when I say biometric data, I mean if you have a system at your organization where your employees are logging in with facial recognition or through their eye scans or fingerprinting, and you're storing that electronic data on your network, that is biometric information that needs to be protected under the SHIELD Act. And then the last part of private information is actually distinct from needing a personal name. And that's important because whereas the other data elements we just talked about, you would need to have that plus a person's name or number or other personal identifier. If you have an individual's username or email address in combination with a password or security question and answer, that in itself is private information. So think about if you operate a location for individuals to come in and use your computer systems, and you warn them not to use the internet for personal use, they're only there maybe to set up their resume or some other means of assistance for employment. But they do use the computer and website to maybe look at their Gmail account or perhaps a Facebook account. And they enter that username and password information, and that data is stored, automatically saved. They click save, and so it's saved in the cache on the computer, and then it's sent to the network where data is stored for your organization, and your organization is breached. That data is private information of a New York resident that was stored by you, and you would have to notify them of any breach that occurred. So the other thing I wanted to talk about is a little bit of a comparison between SHIELD Act and what a breach was defined as before the SHIELD Act was enacted. And that's important for those that may have had some experience with a computer breach in the past before October of 2019. And you might be wondering, well, how is this different? I needed to comply in one way, and what do I have to do? How would it be different now? So one of the most significant changes is that before the SHIELD Act, a breach only occurred if there was an unauthorized acquisition, an actual taking, a copying, a downloading of electronic data. Now, the definition has been expanded to include access or acquisition, meaning simply by viewing the data, maybe not taking the data, but having the ability to see the data, could trigger a notification. And when I saw this change, it just raises a very important question of whether a ransomware attack would be considered access to data. If you're familiar with how ransomware works, it encrypts the data on a computer, and typically the hacker that launches the ransomware is not looking to take the data. They're looking to hold it hostage, and they want to get money for it. So you pay the money, you either get the data back or you don't, but they're not looking to take the data and use it elsewhere for profit. They just want to use that ability to encrypt the data to force you to pay some ransom, hence ransomware. It used to be clear that that was not taking of data, because a ransomware attack would not include the taking of it. But now there are differing opinions as to whether a ransomware attack, when it is not taking data, does that rise to the level of access? So the other piece to know is that the law was expanded to not just cover New York businesses, but it covers all business that would have reason to store New York resident electronic data. That's not as significant within New York, because before the SHIELD Act, when I had New York clients, they were certainly covered. But now there are companies anywhere that if they store New York resident data are covered under this act. With every law, there are usual exceptions. When a requirement to notify is triggered, it's important to know whether you fall into a category of exemption from that requirement to notify. And that would happen if you do an investigation and you determine that it wasn't necessarily an intentional unauthorized access. It was an accidental unauthorized access. Maybe you had an employee at your company that looked into an electronic file they had no permissions to see, and through investigation determined that there's no risk of a financial harm to those individuals. Therefore, you don't have to notify those individuals. There are some caveats to that. So if you do conduct an investigation like that and make that conclusion, then it needs to be in writing, and you should save that documentation for 5 years. And then the other piece of it is that if more than 500 New York State residents were affected, then you need to provide that written documentation to the Attorney General's office within 10 days of such determination, which is a fairly quick round, frankly. And you'll see that the general requirement to provide notification post-breach doesn't have a set time period. You're supposed to do it in an expedient way, but there's no 10-day or 30-day or 3-day requirement. So this is just an important nuance to the law to keep in mind. If there is an investigation that determines that this is not rising to the level of needing to notify, you should keep that documentation. And if that many individuals, more than 500 New York State residents, are affected, you need to notify the AG's office. Okay, so another category of exemption is for regulated industries. So if you are governed by the New York State DFS or HIPAA, then there are a whole body of breach notification requirements under those areas of law. So if you notify New York residents based on a breach under HIPAA, then you don't need to separately send a notification letter to that same resident outside of HIPAA. They've already been notified. That's the whole purpose of this. It's not to create undue paperwork. But you still do need to notify state entities. So if you fall under that category where you've notified New York residents under HIPAA or DFS, then you don't have to send a second wave of notification to those individuals. However, you do need to notify the New York State Attorney General, the Department of State, and state police. Okay, so I mentioned this very briefly, but it's important to know that a report of breach does have to occur what's called expeditiously and without unreasonable delay. What that means is, if there was a breach, first of all, second of all, what is the extent of it? It's not really possible to notify individuals if you don't know who the individuals that are affected are, what data elements were accessed or acquired, and whether or not there was access or acquisition of that data. So you need a full investigation to be able to provide notification to begin with. And if there's an ongoing investigation, in particular a criminal investigation, that is an absolutely justifiable delay under the law. It's written right into the statute. And it just is reasonable to think that way, because you wouldn't want to impede a criminal investigation by sending out notification letters to a significant amount of individuals when someone might be facing a grand jury indictment or some other criminal investigation. So it's helpful. It's a helpful aspect of the law and thing to keep in mind. The other piece of it to remember is, unlike some other more onerous privacy laws, this does provide a good amount of wiggle room for notification. If we were in GDPR land, which is the European data privacy law, there's a requirement to provide notice within 72 hours of learning of a breach. And I really don't see how that's possible with how time-consuming an investigation can be. So what is access? What is acquire? In order for data to be accessed, you need to determine whether there was any indication that that data was viewed, communicated with, or altered. And it would have to be by someone without valid authorization. So this authorization piece is a very interesting one, and it comes up mostly where it's an internal job, if you will. If the breach exists because someone in the HR department or the IT department viewed somebody's personal records that they weren't necessarily required to do as part of their job duty, but they just happened upon it because there were certain permissions in their login credentials, then is that or is that not unauthorized access? And that becomes a little bit of a gray zone. So the authorization piece or lack thereof is something that you'll find is where lawyers come into play, and they can help guide the determination of whether it was authorized or unauthorized person. And then the next question is, well, was data acquired? What does that mean? How do you determine whether certain data was actually acquired? And that arises when there's some type of physical taking of that data, a copying of the data. Say in an electronic fashion, if I send an email from my work account that attaches a PDF or an Excel spreadsheet with private information on it to my Gmail account, that's an acquisition. I've taken the data because I've sent it from one location to another. If I take the data that is in an email from my work computer and I download it to my own personal computer or desktop, that is also a taking of the data. So what is the practical impact? The practical impact is that an organization needs to understand what data they have coming into their network and where it's going. And it sounds like a simple concept, but data mapping can be a significant endeavor, time-consuming and costly. So obviously that's dependent on the size of your organization and whether you have your own IT department that handles your networking or you have a vendor that handles it. And then the other piece of it is understanding who in your organization should have access to what information of customers or employees. And it's important to recognize that not all employees should have access to all other employee information. And similarly, not all employees should have access to all customer information. So these decisions need to be made at a management level to know, especially in an environment, if you are handling sensitive private information of individuals, it's important to set up the correct electronic permissions and credentials for limiting access when it's unnecessary. So you've had a breach, and now you need to provide notice of that breach. Who do you send notice to? What does it look like? What has to be included in it? So you certainly would have to send to the individuals affected. And as I talked about, it's important to know who those people are in order to send the notification. And you would have to also notify the Attorney General's office, the State Department, and police. Actually, if you go to the New York State Attorney General website, there's now a form that you can electronically fill out and submit that includes all of the data elements that you would need to include in that notification. Significantly, if more than 5,000 residents are affected, then you also have to notify consumer reporting agencies. So the reason that the investigation is so important is that when you provide notice, you don't just send a letter to people saying, we had a breach, good luck. You need to say, around this time period, we learned of unauthorized access or acquisition of certain information related to your name and social security number, or if it was account information. You have to be as specific as you can about the elements of data that actually viewed or taken. And again, that information that needs to be in the notice is only going to be determined by a forensic investigation. So one of the topics that I talk on frequently is what's called incident response. And if there is an incident or a breach, then you have a process that you should follow in terms of notifying your insurance carrier, notifying your attorney, getting the forensic company involved as soon as possible to recover data, to make sure your redundancies were in place correctly, and to ensure that there was no migration of whatever virus maybe infiltrated your network to the redundant system, and finally to see what data was accessed or acquired. The notice should also include phone numbers and websites of the relevant state and federal agencies. That piece of the notification letter is pretty formulaic. It's the first page of the notification letter that has to have the most pertinent data or information related to the actual breach, whereas it typically falls on the second page. It's a listing of all the federal agencies that you can call for credit monitoring. What's interesting in New York, and a benefit to many organizations, frankly, is that there's no obligation to provide credit monitoring. I believe Massachusetts privacy law and breach notification law does require a company to provide a year of credit monitoring. So that's one difference that we benefit from in New York. I should also take this time to point out that there's still no federal law governing breach notification or U.S. privacy like there is the GDPR. And that creates a bit of a chaotic system, frankly, for organizations that are functioning and operating throughout the country, because if a XYZ corporation who employs residents of California, Illinois, Massachusetts, and New York has a breach, they have to go through each of those states' laws to determine what they need to do in terms of notification to those residents. And they're all different. Some of them are only different in a minor way, but some of them vary significantly, including, most importantly, the time period in which you need to provide notification. There are several states that require notification within a 72-hour period. So that's an important piece of understanding if your organization suffers a breach. There's something called substitute notice, and this really is triggered in certain scenarios where if providing notification would be more than $250,000 to the organization, say the organization did not have cyber insurance and they're going to be paying out of pocket for the forensic investigation, for the legal counsel to guide it, for replacing their computer network to get up and running again, and for notification, that can be a significant financial detriment to the organization. And so if having to provide that level of direct specific notification to each individual would be that costly, there's the opportunity to do what's called substitute notice. The other category would be either if it exceeds affecting over 500,000 individuals in New York State, or maybe you operate a restaurant or hotel and you don't have the ability to track down every individual and their home address to provide notification. It's much easier. It's not good if it happens, but it's much easier if it is an employee, because you typically would have HR records and you can provide a notification to their home address. But in the hospitality industry, that might not be the case. And so substitute notice is acceptable. But what does that mean? So a business would have to provide a conspicuous notice on their website, which is not ideal, and it hurts your reputation, there's no question. But that is part of the substitute notice, to make sure that it would be viewed by anyone that accessed your website. And it can't be a little tab that says breach at the corner and then you click on it and it says that there was a breach. It actually has to be more prominent on your website. So maybe think about a footer banner or a header banner, which is not ideal again, but provides the right information. And then a second piece of that is notification in a statewide media, so some statewide newspaper. And Joaquin and I were talking about this a little bit before we got started today. His concern was, are there going to be lawsuits about this? Are people going to be suing organizations for not protecting their data, for not notifying them of a breach? And the answer is, for now, there's no private right of action, which means that there should not be some influx of plaintiff lawsuits associated with an organization's failure to provide notification of a breach, or organization's failure to comply with the cybersecurity standards set forth in the SHIELD Act. It is right now only enforceable by the Attorney General. That doesn't mean that some plaintiff might come to try to sue an organization for it, connecting negligence maybe, and we're getting into some really kind of nitty-gritty areas of law that you're probably going to be bored about, so I won't get into it too much. So it doesn't mean that lawsuits won't happen, but they really are not viable lawsuits and should easily be dismissed. So separate from that, if the Attorney General wants to enforce these rules, they can seek damage in the amount of what the actual cost of a loss to an individual or individuals was, and also consequential financial losses. So if my information was taken and somebody opened up a credit card and charged significant amounts of money that I am now obligated to pay, that would be a consequential damage, the breach. And what's interesting is if court determines that the organism was reckless in its failure to notify, so they knew that there was a breach, but they just decided, I'm not dealing with this, people will figure it out, no one's going to get financial harm from what information was taken, I'll roll the dice, they can also be penalized between $5,000 and $20,000. And that is another change to the law. So before there was a cap of 10,000, but now it's 20,000. And the statute of limitations was expanded. So now instead of only 2 years, the Attorney General would have 3 years after the date that they became aware of the failed notice. Okay, so now that we've talked about providing notification if there was a breach, now we can talk about this cybersecurity mandate that is included in the SHIELD Act. And the most important piece of this wave of the law is that it is the first time that New York has set a standard for organizations in terms of what they need to do to protect electronic data. And it includes safeguards for the administrative, physical, and technical handling of data. This applies to, again, any person or business that has private information electronically stored of New York residents. So it doesn't matter if your organization is in Pennsylvania and you happen to have customers that are from New York, you are still covered. So you need to implement reasonable administrative, technical, and physical safeguards, and also part of the physical safeguards we'll get into is disposal of data. Administrative safeguards relate to the management or oversight of the data program. Physical safeguards include sort of protection of where your network is housed, the actual physical space and who has access to that, as well as how long you store data. And then the technical safeguards are mostly related to the cybersecurity measures that your organization takes. You know, what firewalls are in place? Do you have network segregation? So administrative safeguards, the most important piece of this is that you designate an individual to coordinate the security program. And that should result in an actually written information security procedure or plan for your organization, so that there's some guidance and evidence, if you will, for one, forward-looking, so that you know how to create the program and run the program or oversee it if you're in position. And two, if there is a breach and the Attorney General is doing an investigation, the first thing they'll look to is, did you have an information security program and were you following it? So it's not written in the law that you need a written policy, but the fallout of the law requiring a security program and having somebody oversee it is that it's not some esoteric theoretical process that people just follow on a whim. It's actually a concrete written plan that your organization should adhere to. You should identify internal and external security risks. So the internal risks are employees, whether through negligence or malice. Employees are really, they're the front lines of your organization, and they're probably the most vulnerable to being the recipient of, say, you know, a phishing email or some other easy access point of your organization. Which is why one of the elements that is in the statute is that you provide training to your employees for how to protect electronic data. And it also requires provides an obligation to assess third-party risk and understand where you might want to look at your vendor contracts and understand who is responsible for what data at what point. And also you should be able to adjust the security program to address any changes. This is not a static document. It needs to be versatile and basically a live document to shift with any shifts in risk that are identified, as well as maybe business expansion. Physical safeguards are, again, assessing risk, but this risk is what related to how you're storing electronic data and when and how you're deleting that data. You should also be able to detect any physical intrusions into your organization, into your computer network, but also if you have a data center or data room, who has access to that physically that might result in vulnerability. And then data disposal. So this is another area that has created a lot of work for organizations who may not have ever had a written data retention or deletion policy, and perhaps never even endeavored deleting data because they just either lost track of it, or there's this sense of, well, I don't want to delete it because what if I need it 10 years later? The longer you retain electronic data on individuals that you no longer reasonably need for your business or to comply with some other data retention obligation under the law, the riskier it is for that data to be exposed, which is why this provision is in this law and is such a significant piece of the law, because several data breaches have resulted in taking electronically stored data that was probably 8 to 10 years old, and the investigation determined that there was no reason that this organization even needed to have this data, and it would have avoided exposure to that individual had they simply been responsible and deleted it. So this is an area of focus under this law, and has been an area of focus of many of my clients to prepare retention and deletion policies, as well as to sort of do what is the safest deletion cycle of particular data, and are we doing it? So just to the extent it affects, this law affects your organization, and this has not been highlighted for you, it's something to take a look at. And then the technical safeguards, as I talked about, this is more of the computer techie piece of it, where you need to have a risk assessment on how you're storing data. And again, with network segregation, are there certain areas of your business that employees have credentials to access one area of data but not other areas of data? And is it reasonable for their role in the organization? So this brings me to an actual risk assessment. Now, if you look at the letter of the law, it does not say that you need to have a risk assessment for your organization. However, in order to actually comply with those safeguards that we just went through, you would need to have a risk assessment performed. So then what do you think the Attorney General is going to do if you do have a breach and they come in and determine that you haven't had a risk assessment in 5 years? That is a significant vulnerability for your organization that you don't want to put yourself in. So a risk assessment is what it sounds like. You would have an analysis of where your risks are, how to mitigate those risks, where the vulnerabilities exist. Are they in the administrative level? Are they in the physical level? Are you retaining data eternally? Do you allow all employees to access all customer data? Those sort of straightforward elements of your operation are where you would start to assess risk. You would also want to assess where the potential threats are. So we talked a little bit about internal threats, which would be negligent employees, if you will, maybe just employees that weren't trained to spot phishing emails. Or is it a malicious employee that knows their way around a computer and so has decided to extract some private information of customers without your knowledge, and then one day they decide to quit or they're fired and they take that data? Now your organization is likely going to be liable for that taking of private information. And then the external threats are nation-state actors. There's been significant discussion at the federal government level of the risk that North Korea still poses to our cybersecurity. And so it's important to stay apprised, for your director of technology to stay apprised of these risk factors. And then again, identifying vulnerabilities. Are you up to date on all of the software patches for your network? These are items that need to be viewed from the lens of your IT department, and your CIO should also be included in those communications. Have you properly trained your employees? I recommend annual training and onboarding training, as well as when you have an employee that leaves, it's important to go through the checklist of where they may have taken certain electronic files and ensure that they return them. And then what's the likelihood that these vulnerabilities will be exposed? And that assessment is probably best suited for a third party. I've had this question multiple times. Should the risk assessment be performed by an independent forensic organization, a technology company, or can my IT do the risk assessment? Well, your IT department may be able to perform your risk assessment at a fundamental level, and maybe if they do a piece of it and work with a vendor, that would mitigate the cost of it. But to have a outside perspective of where your risks exist is recommended. And something that I expect the Attorney General's office would agree to. And I will admit that I have actually tried contacting the Attorney General's office leading up to the rollout of this law, because there are so many questions that are coming out of the way the law is written, and the only way to know exactly how the contours will unfold is through enforcement actions, which obviously couldn't happen yet because it just came into law. So while I've tried to get direct from the horse's mouth indication in terms of what the focus will be if there are investigations by the Attorney General's office, I have had little success in that. But I will continue to look and monitor the situation. So if anyone follows me on LinkedIn, I try to post information there. I will update as much as I can learn, either through if there are enforcement actions or if I ever hear back from the Attorney General's office. And also the risk assessment would look at what potential harm would there be. You know, each vulnerability would be connected to what would happen if this vulnerability was exploited. And this is just a reminder that that risk assessment, again, should be documented. It should be an actually, a robust written document that identifies all of your risk factors, vulnerabilities, probability, and harm. And I already addressed the who should perform the risk assessment, but it's also important to make sure that the relevant pieces of your organization are engaged in that risk assessment. So it should include all business units of the organization, as well as if there is a legal department, IT department, and the HR department. So you can't just do one risk assessment and be done. Business changes, life changes. Obviously, we're all in this new world where we are living through a pandemic, and things change on a rapid basis. So once you have a risk assessment done and you address what risk factors your organization has and how to mitigate those risks, you should begin a cycle of an annual risk assessment. Or if your organization has some large expansion or is acquired in some segments, so you've been cleaved off in some way, that would be a significant change that you should reassess where your risks are. The other is, are there changes in the law that would affect what your risk exposure is? So it should be again a live document that is looked at least on an annual basis, and then when there's any major change. One very important aspect of SHIELD Act, I hope I didn't bore you too much. We're getting to the end. It's pretty dense material. I hope you find it helpful. But this is helpful to small organizations in New York State or organizations outside of New York that have New York resident data. If your company has fewer than 50 employees or less than $3 million in gross annual revenue for the last 3 fiscal years, or less than $5 million in year-end total assets, you are considered a small business under this law. So it's a different definition than other laws. It's important to know. And if that is the case, then you still are covered by the law. So it's not like you don't have to do something to protect that electronic data, but you don't have to meet all of those safeguards we just spent 20 minutes discussing. What you need to do is act reasonably and what's appropriate for the complexity of your organization and the type of data that your organization holds. There's unfortunately no clear definition from the Attorney General's office or the Governor's office as to what reasonable means. But it is important to keep this in mind, because if you're a business entity that has 10 employees, but you have a wide variety of customer data coming in, you likely have a vendor managing that data. So I would review your vendor contract for that network capability and determine whether the contract assesses who would be responsible for a breach if it occurred outside of your control, and make sure that it's the vendor and that you would not take responsibility for such a breach. We talked about not knowing what's reasonable. We will learn through enforcement what would be reasonable for a certain size organization. So how do you comply with this very dense and not so clear law? We talked about a few different policies that you should have written out if you don't already, which is an information security program, risk assessment, data destruction or restriction, and then an incident response plan, so that you're ready to comply with the breach notification requirements. But I also like to point out that just because you're compliant with the security safeguards of the SHIELD Act doesn't necessarily mean that you're also secure. So this is sort of a baseline of how to protect data, but a computer company would be better suited to review how you're storing data, how you're collecting data, how you're processing data, to advise on what safeguards should be in place to secure that data. And it looks like we are at the end. So if there are questions, please pose them. Oh, I see some. What are the ramifications of folks using personal assets to work from home? Is that the company or the person now responsible? So if you're working from home and you're actually functioning in your role as an employee, that would be your employer's obligation to make sure that your virtual network is set up in a way to protect private information. And are there any guidelines for documentation with respect to holding onto data, not disposing for business purpose? It's a very good point. So there's not an overarching guidance. It's actually very piecemeal, unfortunately, because in some instances, you need to retain accounting information for tax purposes and payroll information. You also should be mindful of any statute of limitations. So if you have contracts that include private information on them and they might be subject to a lawsuit, you would want to retain them for 6 years because statute of limitations for a breach of contract is 6 years. So the answer is it depends on the category of data. And this is something that you would work with your HR department and legal department to determine what are your obligations for each category, because tax documentation is something that would be different than employee information and how long you would need to retain employee information. If you use a bunch of open data and find a way to make the identifiable, can that now count as personal or private data? Yes, so this is where the data scientists need to be mindful of. If data is anonymized and cannot be recreated in a way or reverse engineered in a way to identify individuals, then that's great. But if you can somehow manipulate data to now derive an individual's name and one of those other elements that equate to private information, you're now covered by the SHIELD Act.